Like the Australian Constitution, it has a long list of subjects for concurrent powers of legislation. Under the Australian Constitution, concurrent subjects are 39. Under the draft Constitution, they are 37. Following the Australian Constitution, there are as many as 6 articles in the draft Constitution where the provisions are of a temporary duration and which could be replaced by Parliament at any time by provisions suitable for the Constitution. The biggest advance made by the draft Constitution over the Australian Constitution is in the matter of exclusive powers of legislation vested in Parliament. While the exclusive authority of the Australian Parliament to legislate extends only to about 3 matters, the authority of the Indian Parliament as proposed in the draft Constitution will extend to 91. It has then come to 97, 97 being an omnibus residuary clause. In this way, the draft Constitution has secured the greatest possible elasticity in its federalism, which is supposed to be rigid by nature. It is not enough to say that the draft Constitution follows the Australian Constitution or follows it on a more extensive scale. What is to be noted is that it has added new ways of overcoming the rigidity and legalism inherent in federalism, which are special to it and which are not to be found elsewhere. First is the power given to Parliament to legislate on exclusively provincial.
Go ahead.
In normal times, I refer to Articles 226, 227, and 229. Under Article 226, Parliament can legislate when a subject becomes a matter of national concern as distinguished from purely provincial concern, though the subject is in the state list, provided a solution is passed by the upper chamber, resolution must be, my lord. Upper chamber by 2/3 majority in favor of such exercise of the power by the centre. Article 227 gives a similar power to Parliament in a national emergency. Under Article 229, Parliament can exercise the same power if provinces consent to such exercise. Though the last provision also exists in the Australian Constitution, the first two are a special feature of the draft Constitution. The second means adopted to, my lord, my lord, please come to the next page, my lord, PDF 12.
Yes.
Not that the others are not important, my lord, but then to save time, because anyway, your lordships would be going through it. One can therefore safely say that the Indian Federation will not suffer from the faults of rigidity or legalism. Its distinguishing feature is that it is a flexible federation. There is another special feature of the proposed Indian Federation which distinguishes it from other federations. A federation being a dual polity based on divided authority with separate legislative, executive, and judicial powers for each of the two polities is bound to produce diversity in laws, in administration, and in judicial protection. Up to a certain point, this diversity does not matter.
Just skip that a little bit now and then go to the bottom of that page.
Yes.
The draft constitution has sought to forge means and methods whereby India will have federation.
And at the same time, will have uniformity in all basic matters which are essential to maintain the unity of the country.
And then on the next page, Dr. Ambedkar refers to 3 things: a single judiciary,
uniformity in fundamental laws, civil and criminal,
and all India civil service. That we can then.
Yeah. No, my lord, the rest of it, my lord, but of course, your lordships would be, with the utmost respect, my lord, I would commend that your lordships have a
I think we have seen the key of
yes,
the key factors, the key features
correct
of the constitution which make it federal. At the same time,
yes,
preserve the need for
that's right.
a certain degree of uniformity.
That's right.
At the national level.
That's right, my lord. No, my lord, immediately, if your lordships cut the chase to the closing remarks, that's the famous, my lord, speech by Dr. Ambedkar.
1949.
Yes.
Where is that?
That is, my lord, at PDF page 1299, same volume. Yes. So I would
to read that.
Would you like to read it? No, sir, you can. You can lay emphasis on.
Mr. Giri?
Lord, PDF page 1299. 1299. Starts at 1299. The relevant portion is at 1307.
4160.
Lord?
4160 in red.
Yes, 4160. My lord, see, the relevant portion is again 1307. Continuous page is 4168. Can I read it?
Yes.
There's only one point of constitutional import to which I propose to make a reference. A serious complaint is made on the ground that there is too much of centralization and that the states have been reduced to municipalities. It is clear that this view is not only an exaggeration, but is also founded on a misunderstanding of what exactly the Constitution contrives to do. As to the relation between the center and the states, it is necessary to bear in mind the fundamental principle on which it rests. The basic principles of federalism is that the legislative and executive authority is partitioned between the center and the states, not by any law to be made by the center but by the Constitution itself. This is what Constitution does. The states under our Constitution are in no way dependent upon the center for the legislative or executive authority. The center and the states are co-equal in this matter. It is difficult to see how such a constitution can be called as centralism. It may be that the constitution assigns to the center too large field for the operation of its legislative and executive authority than is to be found in any other federal constitution. It may be true that the residuary powers are given to the center and not to the states. But these features do not form the essence of federalism. The chief mark of federalism, as I said, lies in the partition of the legislative and executive authority between the center and the units by the constitution. This is a principle embodied in our constitution. There can be no mistake about it. It is ever wrong to say that the states have been placed under the center. Center cannot by its own will alter the boundary of the partition, nor can the judiciary, for as has been well said, courts may modify, they cannot replace, they can revise earlier interpretations as new arguments, new points of view are presented, they can shift the dividing line in marginal cases, but there are barriers they cannot pass, definite assignments of power they cannot reallocate, they can give a broadening construction of existing powers, but they cannot assign to one authority powers explicitly granted to another. The first charge of centralization defeating federalism must therefore fail. The second charge is that the center has been given the power to override the state. Then my Lord Dr. Ambedkar says, this charge must be admitted. But before condemning the constitution for containing such overriding powers, certain considerations must be borne in mind. The first is that these overriding powers do not form the normal feature of the constitution. Their use and operation are expressly confined to emergencies only. The second consideration is, could we avoid giving overriding powers to the center when an emergency has arisen? Those who do not admit the justification for such overriding powers to the center, even in an emergency, do not seem to have a clear idea of the problem which lies at the root of the matter. The problem is so clearly set out by a writer in that well-known magazine, The Round Table, in its issue of December 1935, that I offer no apology for quoting the following extract from it. Says the writer, political systems are a complex of rights and duties, resting ultimately on the question to whom and to what authority does a citizen owe allegiance. In normal affairs, the question is not present, for the law works smoothly, and a man goes about his business obeying one authority in this set of matters and another authority in that. But in a moment of crisis, a conflict of claims may arise, and it is then apparent that ultimate allegiance cannot be divided. The issue of allegiance cannot be determined in the last resort by a juristic interpretation of statutes. The law must conform to the facts, or so much the worse for the law. When all formalism is stripped away, the bare question is what authority commands the residual loyalty of the citizen? Is it the center of the constitutional state? The solution of this problem depends upon one's answer to this question, which is the crux of the problem. There can be no doubt that in the opinion of the vast majority of the people, the residual loyalty of the citizen in an emergency must be to the center and not to the constituent states, for it is only the center which can work for a common end and for the general interests of the country as a whole. Herein lies the justification for giving to all center certain overriding powers to be used in an emergency. And after all, what is the obligation imposed upon the constituent states with these emergency powers? No more than this, that in an emergency, they should take into consideration alongside their local interests, the opinions and interests of the nation as a whole. Only those who have not understood the problem can complain against it. No, my lord, there is an anguish. Sorry. Well, let's see. Just one paragraph in the two lines in the next paragraph, my lord. How the in what was the anxiety, my lord, which he shared, and how prophetic, my lord. Sometimes one feels that so prophetic he could have been. Here I could have ended, but my mind is so full of the future of our country that I feel I ought to take this occasion to give expression to some of my reflections thereon. And 26 January 1950, India will be an independent country. What would happen to her independence? Will she maintain her independence or will she lose it again? This is the first thought that comes to my mind. It is not, sorry.
Yeah, this is Aparajita sent me she's
This context.
For this also.
20.
Not that, my lord. These lines which start, the point is, today's context, my lord, the anxiety and the anguish, my lord.
You must complete reading that, Mr. Giri. It's a very interesting passage.
Yes, yes. This is the first thought that comes to my mind. It is not that India was never an independent country. The point is that once she lost the independence she had, will she lose it a second time? It is this thought which makes me most anxious for the future. What perturbs me greatly is the fact that not only India has once before lost her independence, but she lost it by the infidelity and treachery of some of her people. In the invasion of Sindh by Muhammad bin Qasim, the military commanders of Kandahar accepted bribes from the agents of Muhammad bin Qasim and refused to fight on the side of the king. It was Jayachand who invited Muhammad Ghori to invade India and fight against Prithviraj and promised him the help of himself and the Solanki kings. Then, my lords, I'll leave the rest. Next one, will history repeat itself? It is this thought which fills me with anxiety. This anxiety is deepened by the realization of the fact that in addition to our old enemies, in the form of castes and creeds, we are going to have many political parties with diverse and opposing political creeds. Will India place a country above the creed or will they place creed above the country? I do not know. But this much is certain that if the parties place creed above country, our independence will be put in jeopardy a second time and probably we lost forever. This eventuality we must all resolutely guard against. We must be determined to defend our independence with the last drop of our blood. No, my lords, these two, my lord, speeches made by Dr. Babasaheb Ambedkar, two different points of time, one while presenting the draft constitution, the other after the draft constitution concluding remarks. There's not much variance, my lord, except to say that the slanting, my lord, if any, in the distribution of power, lawmaking power, my lord, towards the center was justified by Dr. Ambedkar after the constitution was drafted. No, my lord, it is after taking into all this that your lordships have also, my lord, over the years, after 1950, interpreted the constitution, interpreted the federal structure of the constitution. My lord, it has been done in many cases, but for the present, my lord, can I just give the paragraph numbers, my lord, and the PDF page numbers of some of the judgments, my lord, starting with State of Rajasthan versus Union of India. Just give the citation.
Just give us the page,
Yes.
the PDF
My lord,
volume.
volume 26. Volume 26. My lord, 1977 3 SCC 592.
That's okay. We have just give us the PDF volume now.
Yes.
The
My
PDF
lord, that is PDF page 54.
at
54.
para.
At paragraph, my lord, just.
So you're giving the PDF page of the relevant paragraph of the beginning of the case, whichever way you want to do it. Just give us the page at which the case begins and the
Yes.
page at which you are stressing the
Yes.
extract.
Yes. my lord. PDF 21. PDF 54, my lord, is a relevant paragraph.
All
Three
right.
paragraphs, my lord, from Chief Justice Beck's opinion.
All right, the next.
The next is, my lord, Bommai. Bommai, my lord, is in volume 2. page 2 onwards.
Page, and at page,
My lords, that's what. My lord, there are multiple opinions in Bombay, as your lordships would have.
right, but which are the paragraphs you?
My lords,
which are
the paragraphs, my lord, can I start with, my lord, in the order in which it is given, my lord,
Sure, no problem.
Justice Pandyan's opinion doesn't deal with federalism separately. PDF paragraphs 1 to 9, therefore PDF page 2 to 6. Yes. Sorry, PDF page 65, my lord, sorry, PDF page 65, the rest is all, my lord, editorial notes. Paragraphs 1 to 9, and in para 2, he agrees with the conclusions of 1, 2, 4 to 8 of Justice Sawant's opinion, my lord.
All right, then.
Kindly note that, my lord.
Yes,
My lord, see, PDF 68, Justice Ahmadi's opinion, para 10 onwards.
just Ahmadi.
And the relevant portion, my lord, with regard to the federal character of the constitution is at PDF 69, paragraph 13,
PDF,
69, paragraph 13,
Next,
para 23 and 24 at PDF 75.
all right, next.
My lord, but para 247 and 248 PDF 206. My lord, the paragraph, my lord, Ramaswamy, Justice Ramaswamy's opinion, para 247 and 248 at PDF 206.
All right, so we've covered
My
Bombay.
lords, there is a conspectus of the earlier decisions, including Rajasthan and Bombay, in NCT 2,
Yes,
volume 14, PDF 3, paragraph 68 to paragraph 77.
page,
Paragraph 68 to paragraph 77. Just get the PDF page. PDF page. NCT. My lord, I'll give the page number in a moment. Volume 14.
volume,
14. My lord, it doesn't have an SEC citation so far. SEC online is there.
para 68 to,
Para 68 to para
we'll
77.
have an SCR citation. I think all of you must now get into the
I
habit
think we
of again citing SCRs. SCR is now digital. We have already got an eSCR. Hopefully in the next few weeks, we'll have a digital SCR. Digital SCR is exactly as it appears in the volume, while the eSCR, of course, is an electronic copy. And we have updated the head notes right up to probably the last month or so now. I'm not sure exact date, but we are pretty much now abreast. So we have a regular authorized reporting of reporter of the Supreme Court. Because SCR had fallen way behind its times, but now it's up to date. And it also has neutral citations as well.
Oh, that's right. My lord, it has neutral citations.
But we are now moving from an eSCR into a digital SCR. So the digital SCR will have a volume.
It always had neutral citations, Mulaz. It always had. And we were, in fact, used to only citing the SCR. But then, of course, it was not updated for many.
So I would really encourage all of you to just at least skim through the eSCR and
We'll do that. We'll do that.
and if there are any further improvements to be made, please feel free to let me know because it's a
ESCR in the first 20 years were head notes.
That's right. That's
They
what
were
I said.
outstanding.
Absolutely.
And that is what is missing. They gave complete picture of the case and what your lordship did.
now please have a look at the recent head notes. If there is some improvement, I'll be happy to do it.
My Lord, and the corresponding ILRs in the high courts also.
We have revamped our editorial team for the SCR. We have a much broader editorial team. We also have a Center for Research and Planning in the Supreme Court, which is manned by several very talented young people who have been brought in from outside.
Seems that 24 hours are not enough for you.
They're not, Mr. Subbulal. When I leave for home, there's so much to be done every evening
I
after
know.
that as well.
Appreciate it.
Some throughout outstanding members of our bar with them, perhaps would
Of course, with pleasure.
likes of Mr. Shankar Narayan cannot, I have no doubt.
But please do have a look at our ESCR, and very shortly we'll have the digital SCR. So if there's any change, any improvement, let me know so that we'll do it.
My Lord, do not strictly on this, but then I'll have to anyway, I thought of referring it in another context on which, my Lord, I'll do it in a minute or so.
Also, the
But, my
best
Lord,
part, it's a free service. So you can imagine lawyers
Yes.
across the country from the
Yes.
districts
Yes,
to the high courts have this
Yes.
free availability of
Yes.
resource material. Law colleges which can't afford to purchase software,
Correct.
they have this free service. It's searchable, absolutely. Yes.
My Lord, earlier days I was a reporter for the ILR, my Lord, in the High Court. And one good thing was, my Lord, it kept one abreast with all the judgments, my Lord, which used. But the numbers were not, it was not so numerous then. But when writing the head note always, my Lord, was a task. Giving the head note was always a task, kind of. And one had to send it back to the learned judge, my Lord, to get his approval also. Because otherwise, my Lord, sometimes one misses out the crux of the judgment. Then. My Lord, my Lord, I'll just hand it over, kindly permit me. My Lord, when Bomai came out, my Lord, Bomai was delivered, Mr. Sorabji, my Lord, wrote an article which was published in the SEC. My Lord, just give 5 copies. My Lord, I am not taking your lordships, but when your lordships have the time, just,
Just keep that and put it in the.
Yes. My Lord,
Well,
Mr.
just give us-
Sorabji
what is the-
argues-
Just give us a citation. You don't have to add papers now anymore.
94.3 SEC Journal 1. Just give copies.
1994?
1994 3 SEC Journal 1.
What was Mr. Sorabji's?
My Lord, it's relevant, my Lord, how Mr. Sorabji argues and persuasively how Justice Sawant's opinion, my Lord, should be treated as a majority opinion in Bomai, not on the aspect of federalism. And then my Lord says, my Lord, this I'll immediately say why it is relevant, my Lord, is because it is in Justice Sawant's opinion, my Lord, that paragraph 153 comes as a conclusion. And 153(4), my Lord, especially, that decisions could be taken, my Lord, even irreversible decisions, there is a restriction on irreversible decisions. During the currency of a president's proclamation, till such time as a proclamation, my Lord, is approved by the both houses of the parliament. That's in para 153(4). I think the learned solicitor has brought your lordship's opinion.
Yes, we know
notice.
that.
Since the provisions contained, my Lord, that is at page 149 of the report. Since the provisions contained in clause 3 of article 356 are intended to be a check on the powers of the president under clause 1 thereof, it will not be permissible for the president to exercise powers under subclause A, B and C of the latter clause to take irreversible actions till at least both the houses of the parliament have approved of the proclamation. My Lord, this should be treated, my Lord, in my respectful submission, as the opinion of the bench, as a majority opinion of the bench, my Lord. My Lord, I commend this with great respect. I commend this article of Mr. Sorabji for that purpose, my Lord. When your lordships, it's in the beginning itself, my Lord. It's a page. My Lord, on federalism, I'll just make this proposition, my Lord, and leave it before your lordships. I have given, my Lord, the relevant paragraphs in the judgments, my Lord. I have placed Dr. Ambedkar's opening remarks and the closing remarks. My Lord, especially in the last judgment of NCT 2, where your lordships, my Lord, had a conspectus of the earlier judgments, my Lord, which dealt with federalism. There are 2 or 3 features, my Lord, which your lordships have outlined. One is that federalism is a basic feature of the constitution. No, my lords, when your lordships have said that, the federalism, my lord, that is revealed, my lord, from the reading of the constitution as a whole. My lord, please keep 370 for a moment aside. Is, my lord, where the distribution of the legislative powers with the parliament and the state legislatures, and with the slanting, my lord, in favor of the state. The reasons have all been given, my lord. I need not repeat it myself because your lordships have articulated it so well, my lord, in the earlier judgments. Now, my lords, whatever it is, your lordships will find that 370 constituted when your lordships have a holistic picture of the constitution and the relationship between the union and all the other states. And then if your lordships looked at 370, my lord, put in an area or carved out an area, my lord, which is not in sync with the general federal features of the constitution for the rest of the country, for the union and the rest of the country. Dr. Dhawan, my lord, pointed out other features, my lord, in part 21, 371 onwards. Point is, my lord, over a period of about 25 years, different provisions were introduced, were inserted in the constitution, giving a certain special provisions, my lord, for some of the states, and all, therefore, an amendment of the constitution and the parliamentary legislation. But point is, my lord, there are 2 or 3 features which emanate out of 370. One is that Parliament requires the consent of the state, the government of the state in relation to matters which are included in list 1 and 3, but not relatable to the instrument of accession. That the consent of the state is required for making applicable certain provision, all provisions of the constitution which have been mentioned in clause D.
Just 1 second. As the consent of the government of the state on list 1 and 3 matters,
Yes.
which matters do not relate to the IOA.
Yes.
That's right. Yes.
No, my lord, sin.
That is B2.
Yes, B2. D deals with such of the other provisions of the constitution shall apply in relation to that state, subject to such exceptions and modifications as the president may by order specify. And then the second proviso, concurrence of the government is necessary. That it has been done repeatedly, my lord, from 1950 onwards is a historical fact. But the point is, my lord, this sets out the relationship between Union and Jammu and Kashmir at a plane, I'm not saying higher or lower, I'm saying at a plane different from the constantly interworking relationship between the Union and all other states in the country, all other states forming part of the Union. Lord, when 370 is abrogated, you have a situation, my lord, which is, my lord, please consider the bifurcation of the state into 2 union territories, my lord, differently. That came about on 31/10/2019. I'm saying, my lord, that when 370 was abrogated by 272, and, my lord, all the provisions of the constitution became instanto, eo instanti, applicable to the state of Jammu and Kashmir. Jammu and Kashmir, therefore, became a state, my lord, on a complete par with all other states, my lord, in the union insofar as the federal structure is concerned. Even otherwise. Now, my lord, what do the petitioners want? As a solicitor, my lord, was at pains to point out there is a great deal of expansion of rights, my lord, which could be enforced by the persons who reside in the state. But, my lord, what do the petitioners want? They want the 272 and 273 to be set aside and Article 370 to be resurrected from all the other states of the Union. And the federal working relationship which the Constitution behoves us to do will meet with a roadblock one way or the other. Lord, I'm not saying that the one principle of administrative law which your lordships have always applied is, your lordships would not issue a prerogative writ in setting aside any order or setting aside any action taken by the executive. My lord, if such interference by your lordships resurrects, my lord, a situation that was also not completely legal. My lord, paraphrase it. If setting aside 272 and 273 resurrects Article 370, in my respectful submission, if Article 370 is resurrected, that would also be violative of the basic structure of the Constitution. Yes.
This might be a little too far-fetched because then that would be to postulate that original Article 370 was violative of the
There was a
basic.
challenge. There was a challenge pending here for several years. 1986, my lord, a batch of writ petitions was then made over to the High Court, whether that's still pending. There are people, my lord, who wanted to prosecute it. But of course, my lord, one of the writ petitions challenging 35A is also, my lord,
It was a part of
actually
the
pending.
original constitution, Mr.
I'm saying, my lord, that the federal structure, my lord, I would only, my lord, let me go by the path of least resistance.
Can't invite us to hold in your favor on an unstateable proposition.
No, I'm saying, my lord, that your lordship, let me take the path of least resistance. My lord, the federal structure which emanates, my lord, from 370 is on a different plane from the federal structure.
Mr. Giri, you are not today confronted with a situation where Article 370 is in the Constitution.
I'm saying, my lord, that if there is a resurrection, then, my lord, there is still, my lord, a cause of action.
35A, etc. is on a different.
I understand, my lord. I'm saying, my lord, these,
I think we better wrap up.
I am wrapping up.
11:25.
My lord, just one aspect on which your lordships wanted an answer, my lord. In Madhav Rao Sindhya, my lord, 1971, 1 SEC 85. Volume 6, PDF 390. My lord, I'll just give the page number, relevant PDF page numbers and paragraphs. My lord, Chief Justice Hidayetullah's opinion, para 65, PDF 443,
What
para
volume?
76, PDF 447.
Volume?
My lord, volume 6, my lord, of the case law compilation.
Yes.
Decision starts at PDF page 390.
So what is the proposition you're citing it?
My lord, it's only this, my lord. Your lordship, the solicitor had taken your lordship extensively through Ganpat Rao,
Yes, yes.
which came about later. My lord, the mandamus was issued in Madhav Rao Sindhya, my lord, where after a serious bit of ratiocination, the lordships came to the conclusion, both Chief Justice Hidayatullah and Justice Shah, that the right which is claimed by the petitioners emanates from Article 291, Constitution, and 362, and not from the covenant. And this is same conclusion was arrived at to hold that 363, which is a bar on the courts for not entertaining such disputes, is not attracted because the right claimed by the petitioners is on a right which is generated and frameworked in the Constitution and not in the covenant. That is why a mandamus is issued. You don't have a parallel
One
here.
second. You said that the rights, but Justice Hidayatullah and Justice Shah said that the rights which were claimed by the petitioners originated in Articles 291 and
And 362,
and not in the covenant.
not from the covenant.
And what is the next, what is the sequitur that?
And therefore, my lords, that 363 was not attracted. 363 has been subsequently repealed, but 363 was not attracted. And therefore, a mandamus was issued. Therefore, my lord, the right claimed by the petitioners was under the Constitution itself. 291 and 362 were repealed. Earlier, my lord, it was only a question of, my lord, withdrawing the recognition of a ruler under 366(22). That was found to be inadequate because 291 and 362 were still intact. That is why, my lord, in the first matter, in Madhavrao Sindhya's matter, a mandamus was issued. When 291 and 362 were repealed by a constitutional amendment, my lord, no further right survived. There was no privy purse, my lord, which the right to a privy purse which emanated from the constitution or embedded in the constitution. The right was taken away by a constitutional amendment. That's why, my lord, in Ganpat Rao, a challenge to the constitutional amendment on the ground that it violated the basic structure of the constitution was repelled. My lord, petitioners cannot draw any sustenance, my lord, from the ratio of Madhavrao Sindhya is my respectful submission.
Thank you, Mr.
I am deeply obliged to you.
Thank you, Mr. Giri.
Yes.
Are you appearing for?
For a union.
But for the union, how many people will appear, Mr. Nataraj? We don't want to stop you because it's an important matter, but
Yeah, I'll not repeat anything, and I'm.
can you formulate what?
Yes,
you are-
I'll formulate. I'm cautious of the arguments already advanced on behalf of Union of India, and equally conscious of the time factor which is staring at me through your eyes.
Find you to 10 minutes.
Please. Just I'll only on a different approach which I'd like to give to the entire the facets of this one with regard to the matter. Basically, I formulated 4 issues, which I will cover up in within 10 or 15 minutes. I will not go beyond that. Article 370 is the only provision in the Constitution which has a self-destruction mechanism. There are other articles which would lapse by a flux of time. There is a different scenario altogether. Number 2, this article did not confer any kind of right. Number 3, continued application of,
One.
please, I'm sorry.
Continued application.
Of Article 370 discriminated and opposed to basic structure. Fourthly, doctrine of federalism, a foundation which they are laid.
Just wait.
Please. In the stricto sense has no application insofar as Article 370 process is concerned.
What is the fourth one?
The doctrine of federalism, that federal structure principle, has no application in stricto sense insofar as process under Article 370 is concerned. Now, first let me deal with the last point with regard to the federal structure theory which they advanced or propounded in support of their contention. By virtue of it, the Article 370 abrogation and all this process, the federal structure has been violated. While dealing with that, first let me take the sample code 2. The provisions under the Constitution, where under the constitutional provisions can be amended. That is Article 368. Now kindly take Article 368 in juxtaposition with Article 370. There are 2 situations. Under Article 368, that is the provision under which the Constitution can be amended. That is the provision. which recognizes number one, constituent power. Number two, while amending the constitutional provisions, in most of the cases, we require the majority or the two-thirds of the majority as provided under Article 368(1). The second part is equally important, which recognizes federalism, is the next part, where the ratification. Article 368(2) that recognizes federalism in the matter of amendment to the Constitution.
Yes.
Kindly see the keywords under Article 368. Kindly take the keywords under Article 368. (368)(1), notwithstanding anything contained in this Constitution, President may, in exercise of its constituent power, the constituent power is explicitly brought into the constitutional provision for the purpose of amendment under Article 368(1), in exercise of constituent power, amend by way of addition, variation, or repeal any provision of this Constitution in accordance with the procedure laid down in this article. So, for the purpose of repeal, the power exercised is recognized as a constituent power under Article 368(1). Now, kindly go to 2. An amendment of this Constitution may be initiated only by the introduction of a bill for the purpose of either house in a parliament, and when the bill is passed, each house by a majority of total membership of that house, and by a majority of not less than two-thirds of the members of the house are voting. That is the second part. Then proviso, provided that if such amendment seeks to make any change in Articles 54, 55, and so and so, so and so, the amendment shall also require to be ratified by the legislature of not less than 1/2 of the states. So the collective consent theory is introduced under Article 368 for the purpose of amendment of the Constitution. It is a collective consent which is required under Article 368 for the purpose of amending the Constitution. In a way, it is a veto power conferred upon the majority of the states. Now, have 370, Article 370 in a juxtaposition. Kindly go to Article 373. Notwithstanding anything contained in these provisions of this article, the President may, by notification, declare that this article shall cease to be operative or shall be operative only with such exceptions or modification as may specify, provided that the recommendation of the Constituent Assembly of the state so and so shall be necessary so and so. 368 speaks of the ratification, a collective consent, and the veto power as a recognition of federal structure is embodied under Article 368. However, when it comes to Article 370, the language is only recommendation, which already they pointed out, it is only
It's been argued consistently. The word recommendation has been argued.
argued. Therefore, I am not touching. I am pointing out the difference between the ratification as a matter of the federal structure which is brought in for the purpose of amendment, and 370 which only says the recommendation. So,
But equally, the adaptation to the Constitution ensured that even in the matter of an amendment,
yes,
the President has to still go through the route of Article 370(1).
absolutely, absolutely. Therefore, in the stricto sense, Article 368 principles of getting it ratified will not be applicable to when it comes to 370, only the recommendation is required, which has a very, very limited.
When additional safeguard was introduced.
Correct.
And that safeguard is not merely in matters which require ratification by half the states.
Correct.
But any constitutional amendment has to go through the process of Article 370
370.
in relation to J&K,
JNK.
as it then stood.
Yes, that's right. But however, reading these two articles in a different language will make either of them redundant. Otherwise, straight away we can go under Article 368 for any kind of amendment of the Constitution.
Other amendment provisions will have impact on different states.
Correct.
It's the provision which only has an impact on one
When,
state.
yes, when the larger power under Article 368 itself is conferred for the purpose of certain amendments of the Constitution. When 368 itself is available, there is no question of applying 370. Reading in any other form makes 370 redundant. Or if you apply 370 in any other form, 368 makes redundant.
It's always been put to us that 373 was a self-destructive mechanism so far as 370 is concerned. That we've already noted.
Mr. Nataraj,
Please.
what you're probably trying to highlight
Please.
is that the argument that the federal structure gets affected because of abrogation of 370
Yes.
should not be accepted for the reason
Yes.
that the federal structure is protected by 368
Yes.
itself. And you cannot say that federal
Absolutely.
structure is diluted in case 370.
370 is concerned. So federal structure is applied and protected under Article 368 and under Article 370. There is no such strict application of federal structure for the purpose of Article 370. Any other interpretation would in a way makes either 370 or 368 a redundant provision. No constitutional provision. So therefore, power conferred under Article 370 is a unique, superior power. It is neither a constituent power, nor a legislative power, nor an executive power. However, it has the flavor of all three. It is a superior power conferred under the Constitution on the President to introduce.
Now look at our problem.
Yes.
Your two ASGs arguing two different things. Mr. Dwivedi said it's a constituent power.
It has
You are
the
saying
flavor.
that-
Yes, it
Of
has.
course, Mr. Dwivedi is not an
it-
ASG, but
it-
the point is he's on your side.
Yes.
Now, at some point, we were told that they had differing interpretations. Now
Yes.
we are in a situation where the respondents are coming with.
It has the, yes, it has the flavor of all three. It has the flavor of all three.
What I don't understand is.
Yes.
Attorney and solicitors are given a perspective of how the constitution is understood from the
Yes.
government perspective.
Yes.
Will we have different perspectives?
No, not at all, not at all, not at all. It is in line with the argument advanced by learned Solicitor General. What we say that it is a unique, extraordinary power conferred on the President to abrogate or to bring in certain changes in the Constitution, which has the flavor of constituent power, which has the flavor of executive power, which has the flavor of legislative power. So that is a plenary power conferred on the President. And when such a power is conferred on the President, plenary power, we need not or we should not treat with any kind of limitations for exercise of such power. Such an extraordinary power conferred on the President need not be or should not be read with any kind of limitations. And it must be given fullest meaning and to be applied without any procedural restrictions.
The proviso has to be forgotten.
Proviso has to be followed. There is no doubt about it. But you can't equate with the Article 368 that the stricter.
If the proviso has to be followed, then what happens to the requirement therein?
No, the requirement is correct, but the yardstick is totally different. We can't equate with the procedure required to be followed under Article 368. proviso need not be in the stricto sensu, need not be followed. And when it's a plenary power, it need not be read with the limitations as held in R versus Burra, which has been applied in the Keshavananda Bharati.
Thank you,
And-
Mr. Nathan. Thank you very much, Mr. Nathan. Mr. Jetnani?
Clarification. Whether the power is constitutional power, executive power or administrative power. But that exercise is irrelevant. It is a sui generis power given only in one article to the highest constitutional. That's not the position.
Yes, Mr. Jetnani.
Now I appear for the interveners in 171690.
Could you repeat that, Mr. Jetnani?
But I number 171690 in in the lead petitions, in the lead petitions. I am the intervener. One of my clients,
In 1047.
yes, in 1037.
1037.
Well, my clients basically are members of the Gujjar Bakarwal community in Jammu and Kashmir. They're members of a scheduled tribe. And now they constitute 73.25% of the total scheduled tribe population of Jammu and Kashmir.
73.25%.
73.25%. But of course, we strongly support the amendments for the reason that the provisions in the Constitution pertaining to scheduled tribes, 330, etc., were never applied.
But Mr. Jetnani, your knowledge is theoretical unless you can state with
Yes,
certainty before us that you have driven around in Ladakh. Have you been?
I have been to Ladakh. I have been to Ladakh. But Manoj, many years ago, many years ago, Manoj, in the days when houseboats used to flourish, in those days. And they've come back now.
Houseboats are not there in Ladakh. In Ladakh? I have not seen a houseboat in Ladakh.
No, houseboat in Srinagar and then
Srinagar.
from there on.
They still. Government claim.
Why don't you go there? I'm told a lot of people go there now. It's go there and take a look for yourself. Empirical evidence will stare you in the face. The Himalayan car rally, which used to take place then in the former days, has now been revived. My daughter's scheduled to go soon to Leh and Ladakh in that Himalayan car rally. So they're taking a sports car themselves and traveling up. She and her friends. That's how practical it is
Justice
now.
Variava used to participate.
Yes, but your lordship is right, Justice. But all affirmations from the reaffirmations from the other side about the congenial climate that now takes place in Jammu and Kashmir. But my clients are restricting themselves to the challenge to 373 and the proviso thereto, as also to the amendment to 367 brought about by CO 272. I'm not going into the question of 356 and the territorial reorganization. That's beyond tribal folk. And 356 really deals with the satisfaction of the president and the governor's report and so on. Matters which are best dealt with by the government. So I'm not going into that. I'm going into these two questions only.
So you're going to go into 373?
370, the proviso,
And
and 367 amendment, which replaced by CO 272, dated 5th August 2019, which substituted the word Constituent Assembly with the word Legislative Assembly. Incidentally, I might just mention that my clients are the beneficiaries subsequent to 5th August 2019.
actually, you very helpfully identified the 4 key areas in the case.
Yes.
Which the case turns. 1, 370 itself, and the proviso to 370 bracket 3. 2, the use of the amending power under 367. 3, the reorganization, and 4, 356.
Those are really the 4 issues which arise in this.
4 areas, I would say, for the issues which arise from.
So with regard to the latter two, I'm adopting the arguments of the state, of the government.
All right, how would you formulate yours so that then we
Yes.
can?
I submitted written submissions
Yes, we have got that.
2 days ago, yes, sir. But I briefly on the question of sovereignty, where does sovereignty lie? Because it then dovetails into the question, which are the subject matter of the 2 issues I'm going to deal with. Just a brief overview about the sovereignty question. And I divide it, sovereignty can be looked at in various different ways. There are many divisions, external, internal, political, legal. But I'm going to just talk about the political and legal sovereignty very briefly, these 2 issues. And as far as political sovereignty is concerned, there is no doubt that the other side has not even seriously challenged its political sovereignty rests with the Union. And the clearest indication of that is the preamble.
Union.
Political sovereignty rests with the Union. Qua the state. And a simple look at the preamble, my lord, would indicate that. The preamble of the 2, the Union and the Federating Unit of the state of Jammu and Kashmir, would reveal that. A point noted by Justice Nariman in the State Bank of India case. I mean, we'll kindly have a look first at our preamble very quickly. We, the people of India, having solemnly resolved to constitute India into a sovereign, the word sovereign is key, socialist, secular, democratic republic. Now, in contrast, the Constitution of Jammu and Kashmir has the following preamble. We, the people of state of Jammu and Kashmir, having solemnly resolved in pursuance of accession of this state to India, which took place on 26th October 1947, to further define the existing relationship of the state with the Union of India as an integral part thereof. So now the preamble itself makes no mention of sovereignty. In fact, the preamble is dealt with further defining the existing relationship of the state with the Union as an integral part thereof. So it's an acknowledgement of the Union's sovereignty over the state. This is political sovereignty. The Constitution was geared towards defining the relationship of Jammu and Kashmir for the Union as an integral part of the Union.
Yes.
And first and foremost, the permanent residents of the state of Jammu and Kashmir are citizens of India. Although Mr. Lord may sometimes behave that he's not, but in fact he is. Now I come to the question of legislative. Sorry. Legislative sovereignty is divided between the union and the state. And on a look at Article 370, which is the governing article of the relationship between the union and the state. Matters in the concurrent and union list acceded to by the then Maharaja are within the realm of the center, the union. And broadly speaking, the other parts of the constitution are within the jurisdiction of the state. And
But therefore, the sequitur of your argument would be that matters which do not form part of the instrument of accession in relation to which the union was given exclusive control,
Yes.
the four matters,
yes,
the legislative sovereignty would therefore continue to vest with the Jammu and
continue to
Kashmir,
vest, subject-
Legislative Assembly.
subject to the power of the president to apply the provisions of the constitution under B 1 and 2, but with the concurrence or the consultation of the state. So any provision, theoretically speaking, if those qualifications arise, if that concurrence or that consultation takes place, then the entire constitution can be applied to the state of Jammu and Kashmir under 371. 373 is distinct from 371 because it's at a one-stroke abrogation of the entire Article 370.
Therefore, Mr. Jitnani, you therefore also necessarily accept that there is a concept, sovereignty has two connotations.
Yes.
One, external sovereignty,
Yes,
which undoubtedly vests completely with the Union of India. Internal sovereignty, which is then distributed between the Union and the states.
yes, yes. That's a patent look at that. Nobody can deny that. But the Constitution envisages that from time to time, further and further, and that's been as has been pointed out repeatedly during the course of these arguments, that with the passage of time from 1950 onwards, more and more provisions of the Constitution have been made applicable. And some of them are those which were not originally applicable to the legislative or within the legislative jurisdiction of the center. But ultimate legal sovereignty rests with the union. And though that is Article 373. Article 370, sub-article 3 is indicative of the fact that ultimate legal sovereignty, in the sense that you can get rid of the tunnel altogether that connects the union with the state legally and constitutionally. Ultimate legal sovereignty rests with the Union of India. And 373 is key, is one of the key issues in this entire discussion. It's in all these arguments, 373, and the reading of the proviso, the effect of the proviso. That establishes most of the issues that arise in this case, at least it sets a platform whereby the others can be. Absent that, there would be nothing else, which is why the other side is at pains to point out that after the Constituent Assembly dissolved or became extinct, 373 has no application. In other words, the substantive part of 373 is now swallowed by the proviso. The absence of the Constituent Assembly and the power of recommendation which was vested in it has now disappeared. That's their case. Now, on that proviso, I'll have something to say. But this is the sovereignty issue. Now, there is also Article 147, which is some indication of legal sovereignty of the state of Jammu and Kashmir. That's the amending part. That is an acknowledgement. The third part of C, clause C of 147, is an acknowledgement by the state of Jammu and Kashmir that they cannot touch the Constitution of India as applicable to the state of Jammu and Kashmir. About the issue of Article 373 and the proviso thereto, it actually dovetails into three questions which I'll just frame, which are at the heart of the controversy here. The first is Article 370 temporary or permanent? Did the extinction of the Constituent Assembly of Jammu and Kashmir referred to in the proviso to that article render entire Article 373 oshos? And third, was the amendment by CO 272, dated 5th August 2019, to Section 377, to Section 367. Sorry, to Article 367. Article 367. By the addition of clause 4D, well, that article which made Constituent Assembly read as Legislative Assembly, was that constitutionally valid? I'm not.
Just since we have 55 minutes now to lunch, we'll give you time till 12:20. Mr. Guru, 12:35. Then we will hear the interveners for 2 to 5 minutes, and then we'll give Mr. Banerjee the interveners between 12:35 and 12:50, and Mr. Banerjee 12:50 to 1. That's the way we'll do it.
But because I have to read some extremely important constitutional orders, see, just very briefly.
Give us the page.
Yes,
reference
but I
and
just
the
want to read
para.
the portion that I'll tell your lordship what my argument, I'll come to in a minute.
Well, let's get to the argument.
Yes,
We
yes,
are losing
let's
time.
not
15
waste
minutes
time,
available.
time management, I agree.
Yes.
My lord, as far as the temporary and permanent part is concerned, two issues have already been discussed. One is Article 370 is a provision that is a part of Chapter 21 of the Constitution of India, which deals with temporary provisions.
Yes.
Lordships have already noted that. Second is the title of the article, which describes its provisions as temporary provisions with respect to the state of Jammu and Kashmir. And my lord, third is the effect of the proviso requiring the prior necessary recommendation of the Constituent Assembly of Jammu and Kashmir before the President can act under 373(1).
Your contention is that the Constituent Assembly of Jammu and Kashmir was necessarily limited in point of time and purpose.
But I'll tell
Time, the framing of the constitution for the state, purpose, once that purpose was over, it had to come to an end. That's your submission.
and one of the proviso, and not just one judgment, which I'll just give your lordship the citation, that it is a principle of construction that unless clearly indicated, a proviso would not take away substantive rights or powers conferred by a section or a subsection. Now that's Madhu Gopal's case, and the citation is in my written submissions. Paragraph 7.
Just give us the volume, PDF
Yes.
page and para.
But I've annexed it to my note. But if your lordship wants it in the PDF,
Just give it to us here, we have taken it.
I don't think
You
it's
don't have to flip.
it's not in the PDF. I'm not.
It's not,
It's not in your lordship.
Case law PDF.
case law PDF.
It's a very short judgment, but literally 2.5 pages.
Anyway, GP Singh's interpretation of statutes, a whole section on how to construe a proviso.
Yes.
Sometimes it's explanatory, sometimes it's an exception, it's clarificatory.
But the principle seems to be that unless clearly indicated, it would not take away the substantive rights conferred by the main section.
All.
Now, just a look at 373 and then I take you to my submissions on this most important point.
Yes.
Now, the Constitution and its provisions have to be looked at the perspective of people drafting it in 1950. Well, in 1950, when they did not know who the ultimate constituent power would be in Jammu and Kashmir. Essentially, what was 370? 373 which talked about the article ceasing to be operative altogether. Because it was the terminus of of the entire article. That article required the constituent power on behalf of the Union, acting on the one hand, which is the President of India, qua 370 and Article 3, qua Jammu and Kashmir through Article 370, he was acting as a constituent power. And on the other hand, the constituent power for the state of Jammu and Kashmir at that time was the Constituent Assembly. All documents from 1948 to 1950, all constitutional documents indicate that a Constituent Assembly for the purpose of framing a constitution was necessary, and that was the way forward, which is why Article 373 referred to the Constituent Assembly. But that didn't mean that once the Constituent Assembly completed its task, which was the task of framing the Constitution, that Article 373 would have no meaning, it would be ocious. Now, on the contrary, the COs issued from 1948 onwards, and now this is important, indicate two things. I'll just take a lot very quickly through those COs now.
What do they indicate?
Yes. First, they indicate expressly that the Constituent Assembly and the Legislative Assembly, insofar as it applies to Constitution of India, are synonymous. In other words,
Come again, that the Constituent Assembly,
and the Legislative Assembly are synonymous. I'll point out that expressly.
where do you get that from?
From the various orders right up to 58. That they are to be read as the same. They are to be read as the same. Now, your Lordship may kindly see straight away the first one, which is CO10. CO10? What's the date? CO10, 26 January 1950. Now, this was the same time as the Constitution. Adoption of our Constitution. 26 January 1950. This CO
So what part of CO10 are you relying upon?
Second schedule. Where's it? The PDF page?
Just give us the volume and page.
Yes.
Just so that we have it at one place.
Documents volume 3, PDF page 7.
What does the second schedule do?
Now, the second schedule says, Articles 54 and 55 shall apply, subject to the modifications. Now, Articles 54 and 55 refers to the elections for the President of India.
What's the PDF page number?
Yes.
Page 7.
Page 7.
Seven. In documents volume 3.
Volume 3?
Yes.
Yeah.
This is in column 3 of the second schedule. That the reference to the elected members of the legislative assemblies of the state and to each such, has the Lordship got it, man?
Yes.
And to each such elected member shall be deemed to include respectively a reference to the members of the Constituent Assembly of the state.
Because there was no legislative assembly at all.
There was
at
no
that
legislative assembly. So I'll show you. There was no, absolutely right. There was no legislative assembly at that time. But even when there was, so look, that's the whole point. The point is, it was deemed to be a legislative assembly for the purpose of our constitution. Why was this necessary? In 55, they were trying to get members of the Legislative Assembly of Jammu and Kashmir.
All right, which is the next point, which
Yes.
is the next article,
The next order. So by a deeming fiction, the Legislative Assembly members of the
Give us
constitution.
the next one because we are now
Yes.
5 minutes short of the.
Yes. Then my lord, the next one is CO 39. That's at PDF page 10. See, volume 3 again, PDF page 10.
CO 39.
PDF page 10.
Yes.
Reference to the elected members of the legislative assemblies of the states and to each such elected member shall be deemed to include respectively a reference to the members of the constituent assembly of the state and to each such members. Now, in CO 48, which is the next one, I'm running through it now, and this was in 1954. The date of CO 48 is 15th May 1954. Now, in this CO,
That CO you're saying?
so that's about volume 3, PDF page 13. And I'm reading at page 18.
That is CO number?
48, dated 15th May 1954.
Right, that's a 54.
Yes.
At page 18. All right.
Now, in this CO, for the first time, previously it was done by COs. But for the first time, Article 367 was amended
Right.
as applicable to J&K.
How is it relevant for your argument that Constituent Assembly means Legislative Assembly?
Because that's what the Union of India has done. They've amended 367.
It's clause D.
Yes, yes. That's CO 272, which is under challenge. The same procedure was undertaken in 1954. For the first time this was done.
This was also pointed out to us by, I think, the learned solicitor.
In fact, that's in his list of days. It's the first exercise of 367 power.
But it was even, yes. But even earlier, they were synonymous. The Legislative Assembly and the Constituent Assembly.
Again,
It's
this is 14th
emanated
of
from
May
1948.
1954. This 14th of May 1954.
Yes, 15th of May 1950.
Right. When there's no Legislative Assembly in Jammu and Kashmir.
No, it's not. But now an amendment is made that they will be the same. Even when there's no Legislative Assembly. And now we are not talking about for the purpose of a presidential election. This is now for every purpose.
All right. Which is the next CO?
Then, my lord, your lordship, I just see a provision in the Constitution of Jammu and Kashmir, 85(2), 85 subsection 2. This is at PDF page 56, volume 2.
PDF page?
PDF page 56. until rules are made under subsection 1, the rules of procedure and standing orders in force immediately before the commencement of this constitution with respect to the Constituent Assembly while discharging the functions of the Legislative Assembly shall have effect in relation to each house of the legislature. There was only one. Subject to such modifications and adaptations as may be made therein by the Speaker of the Legislative Assembly or the Chairman of the Legislative Council, as the case may be. My Lord, substantively and in matters of procedure, the Constituent Assembly and the Legislative Assembly. In fact, what emanates from all this is that the Constitution.
But Mr. Jethani.
Yes.
The fact still remains that after the Constitution of Jammu and Kashmir was framed.
Yes.
On 26th of January 1957.
Yes.
Article 367 4D was again amended.
Yeah.
So delete clause D.
Yes. But my Lord,
So that equivalence between the Constituent Assembly and the Legislative Assembly ceases the moment the Constitution of Jammu and Kashmir is framed.
Lordship is absolutely right. Now I'm coming to that last one in 58. That's the last piece. But my Lord, what happened is.
That you will find at your volume 3, page 25.
Yes, Your Lordship is at page 25. And that's. The point is, all this shows that the Legislative Assembly, and why was this deleted? This was deleted because after the dissolution or the extinction of the Constituent Assembly, the constituent power in Jammu and Kashmir was now the Legislative Assembly. The power of amendment, in Article 368, it's in virtue of its being a constituent power that Parliament can amend. This is also recognized by at least 3 judgments in Indira Gandhi's, Nehru's case with Raj Narayan. I go back to the beginning of what I said, right at the outset, that the idea was that 373 being the final step, after which Article 370 altogether ceased to exist.
The only distinction is that a legislature which exercises the power of amendment is not a Constituent Assembly. It's exercising a constituent power.
I agree it is. But otherwise, the alternative interpretation would be that abrogation ceases to exist. You can never abrogate Article 370. That would be the alternative conclusion. We have to see why Parliament amended to Article 370 through 367 in the manner which it did. That's the whole challenge to 272. That is the whole challenge. And it did so because not only was it synonymous for they wore 2 hats. The Constituent Assembly wore 2 hats. The same people, the 75 people who constituted the Constituent Assembly in 1951 when it was convened, were the same people who were also members of the Legislative Assembly.
Argument of the learned solicitor is that independent of the amendment of Article 367,
yes,
370 bracket 3 and the exercise of that power still stands.
Of course it stands.
And it still survives.
Because I'll tell you, Lordship, why.
I have to go as far as, according to him, he has not pitched it. Though he said, look, 367 has also been used in the past.
Yes.
To the 3 times it was used.
Yes.
But he said, independent of 367,
it can still be done. Look, which is why I come to my next point. And that's one of the 367. They became the successors, They were certainly the successors. If there was any constituent power which could replace the Constituent Assembly in the proviso, it was certainly only the Legislative Assembly. Now, your Lordship is right, 367 could not be the source for, that did not necessarily have to be the source for that replacement between the Constituent Assembly and the Legislative Assembly. Did not have to be a source. But it was implicit in any event. All 367 did, or the amendment to 367 did, by CO 272, was to recognize an implicit position. It was not only synonymous for a substantial period of time, but it was a successor. And CO 272 did not make a substantive change. it made a change it was a clarificatory change, which was already inherent, which was already implicit in Article 373 proviso.
All right, anything else, Mr. Jaipullani now?
So now the Damnu's case applies. Please, one look at Damnu to consolidate this argument.
Damnu we have seen, we'll have a look at it.
Just some paragraphs with special emphasis.
Which are the paragraphs? Just give us.
Yes, I'll give a lordships the paragraph. Paragraph 25. Oh, no, I put it in my list. Lordship, just give me a minute. Yes. My lord, the factual situation, which my lord makes the question of law decided clearer, is in paragraph 6, 1, 7, and 8.
Of Damnu.
Of Damnu. That's the factual situation. But if your lordships recall, it was that change. It was that change of Sadr Riyasat to the governor of Jammu and Kashmir. And my lord, the findings are at 19, 22, actually 19 to 28. 19 to 28. And though the 367 was upheld by that constitution bench, the amendment to 367 was upheld by the constitution bench on the ground that it was merely a clarificatory. It was not an amendment of substance. So also here, I bring my submission within the four corners of Damnu
All right.
that this was inherent.
Anything else, Mr. Jaipullani?
No, my lord,
Because now the second point you have covered is.
my lord, and as my learned friend pointed out, that Damnu also refers to it. Damnu says it's sought in aid of its judgment, section 18 of the General Clauses Act.
Yes.
So, my lord, General Clauses Act applies because it's my contention that the Constituent Assembly is the successor. So the Legislative Assembly is the successor, and section 18 of the General Clauses Act will squarely apply. As it does. So the powers vested in the original authority will devolve to the successor authority. In this case, the Constituent Assembly, the Legislative Assembly.
Thank you, Mr.
Right.
Thank you, Mr. Jaipullani. Yes, Mr. Guru.
Wait, please. So, I appear in IEA Malod's 9596, in WP Malod's 1037 of 2019. Malod's, just a minute, Malod's aside.
Were the applicants?
The applicants, Malod's, are persons, displaced persons from that portion of Jammu and Kashmir, which is now called Pakistan occupied Jammu and Kashmir. They represent that set of people, Malod's, and their interests. These are the interveners. With prejudice to my time limit, which my lords have given, just an aside, my lords, I'm reminding myself of being that apocryphal son-in-law under Hindu law, my lords, which Sir Alladi referred to. Apparently, my lords, there was a very intricate problem of Hindu succession under Mitakshara and Dayabaga law before an English judge. The questions were getting so complicated that the judge tongue-in-cheek asked Sir Alladi, what would the son-in-law get? I believe Sir Alladi said, whatever he is able to lay his hands on. That my lords, seems to be my position in terms of, my lords, both time and submissions to really.
So what are the key submissions?
Key submissions, I'll refer to this, my lords. The rights perspective is probably the decisive factor in determining, my lords, the tenability of the challenge which has been mounted by the petitioners. In other words, my lords, the rights perspective will trump or override all or any contentions or allegations of processual infirmities. And the reason why I'm making this submission is this, my lords. Whether it be these intervening applicants or any of the other intervening applicants whom Mr. Salve represented, Mr. Giri represented, or for that matter, Mr. Jethmalani represented, they represent a cross-section of people from Jammu and Kashmir who have suffered discrimination and loss of rights. Therefore, they impugn COs which make provision for rights for such people across the spectrum. The validity will have to be seen in that perspective and in that light. That's my submission for my lord's consideration. For example, my lords, these intervening applicants whom we are referring to, they are probably, my lords, the first victims of the problems which occurred during partition. When the aggression took place and the incursion came, these are the persons who were displaced by force of circumstances from those areas, Mirpur, Gilgit-Baltistan and all those places. They moved therefore to other parts of Jammu and Kashmir and to other parts of India. Now, what is really the problem that they have suffered over the decades now? Because of Section 6 of the Jammu and Kashmir Act, Jammu and Kashmir Constitution, and 35A of the Constitution of India is applicable to Jammu and Kashmir. 6 purported to set out who permanent residents are. (35A) introduced, my lords, by constitutional order in 1954. CO 48. That, my lords, provided that permanent residents, as defined in 6, they will get certain benefits. And the fact that persons who are not permanent residents will not get those benefits cannot be called in question as a matter of justiciability.
Guru, just one clarification.
Yes, my lords.
People who came from the Pakistan occupied Kashmir,
Yes.
they were not given rights under 35A?
No, for the reason why, I'll tell my lords why. Because that referred to permanent residents. Permanent residence as defined in the Act is any citizen of India, but subject to 3 important riders. Rider number 1. The person must be a state class citizen 1 or 2 as of 14th May 1954. 1. 2. He must be ordinarily resident in the state of Jammu and Kashmir during a period of at least 10 years prior to that date. So the date is shifted back to 1944. That therefore, my lords, meant that even those who were there citizens in Jammu and Kashmir in their own right, because of the external aggression during September, October of 1947, they are excluded. That's where the pinch is, my lords.
If they had settled down in other parts of the country, they would have got citizenship.
No, they would have had to be only,
Other parts of the country.
yes, they won't get. If you're in Jammu and Kashmir, yes. But if you went to other parts of the country, you won't get.
Sorry, you're saying
Yes.
the other way around.
May I show 6, my
You're
lord? May I
saying
show-
the other way around.
No, may I show 6, my lords? Can I show 6? Give me 6. Just give me 6.
Jammu and Kashmir Constitution is in part 1 of
Yes.
the document. Part 2. Part 2.
Volume
Volume 2.
2, my lords, page 18.
Well, I'm sorry to interrupt, there are 10 petitions here which challenge 35A. Well, those have to actually be de-linked because we're not here concerned with the challenge to 35A. We're concerned with 370. So, well, all that is fine, but that's not to be decided by your lordships. If this is upheld, if what the union is saying is upheld, this is unnecessary.
That's why.
Doesn't exist.
Mr. Sibal, therefore we are going into this.
Then
Just-
I'm only saying, Malaz, this is only to
Let's-
take up the
let
time
me-
of the court. That's all.
Every person, I'm at, my lords, volume 2, PDF page, my lords, 18. Every person, may I read it, my lords, is deemed to be a citizen of India under the provisions of the Constitution of India, shall be a permanent resident if on the 14th day of May 1954, he was a state subject of class 1 or of class 2 or having lawfully acquired immovable property in the state has been ordinarily resident in the state for not less than 10 years prior to that date. Any person who before the 14th day of 1954 was a state subject of so and so, and who having migrated after 1st day of March 1947, this is an anomalous provision, I'll just show that, my lords. So the first part is 6.1. That talks about two dates, 1954 and 10 years prior to that. Second,
It's an alternative. A and B is an alternative.
that's right. Or, that's right. That's right. But then in terms of actual application, they have always been applied together. All these are persons,
They have been applied, treated as cumulative.
yes, you are outside Jammu and Kashmir, you don't get it. In fact, I've given in my application, my lords, the case of how 8,700 people and odd people left that place during that time, during partition. Today, my lords, after the promulgation of the impugned COs, at least 23,000 people have received domicile certificates. About 24,000 people. We have mentioned that in our submissions.
So state subject of class 1 or clause 2
Yes.
is defined in clause 3,
Yes,
subsection 3.
yes,
Namely, that refers you to
1927.
So
That's right.
you're out there.
yes.
You don't come in there.
No. In fact,
Clause 2.
no, because by 47, by 44, what happens is this, my lords. They expect you to be holding property as of 1944. And even though I qualify, in fact,
Let's say in POK, they're not governed by clause 3 of section 6?
no, my lords, what will happen? They will be governed by clause 3. That's why I'm saying it is applied cumulatively. You should be a state citizen, state subject of class 1 or class 2, and you should have been holding.
It says or.
No, but cumulatively it's being applied where you should have held property as of 44.
But then, Mr.
No, all I'm saying is this.
Mr. Kishan, I don't think 2 can be read as cumulative because it imposes a condition of owning a movable property.
No, I follow.
That owning property.
No, no, I understand. But the fact of the matter
It
is,
cannot be.
the fact of the matter is, my lords, they were entitled, but they have not been provided. That's the actual position.
Only thing is because under A and B, if you're not under A, if you're class A and class 2 citizen, then you have to go for 1927.
1927.
Get documents of 1927 will be very difficult for anybody.
That's another aspect, absolutely. I bow down to that.
Now in clause B, prior to that date refers to which date? 14th of May 1954?
Yes, that's right. 1954. That 14th of May 1954.
Yeah, for clause A, subsection 3 applies.
That's right,
There
27.
is a 1927 order.
Correct.
For clause B, you have to own property and you must have been ordinary resident at least for 10 years prior to 14 May 1950.
I bow down. And
So
that date,
anybody from 14th of May 1944 onwards
that's right.
comes within the
You should have held property, and that 1954 date, my lords will recall, is the date of CO of 1954.
That's also very odd because
Yes.
to say that you must own a property to get citizenship.
Exactly. Now, one more thing, my lords, one more aspect, my lords. Please have a look at 2, section. Yeah, that's right. Yeah. It's a
you're really trying to say is you're supporting the CO 272 and 273
Correct.
by pointing out the anomalies which would otherwise arise
I
as a
bought
result
on-
of Article
I bought
35,
on.
Section
The
6 and 35.
I bought on the challenge, my lords, would really mean that they want to resurrect, amongst other things, this and 35A. That's the point.
Of course, challenge to 35A has.
It stands, but
Kept aside.
I bought on, my
An
lord.
application to assist. Otherwise, that challenge has been kept aside to await the fate of the decision.
I bought on, my lords, but then
Provision-
I'm saying
provision-
that this is important.
A provision which doesn't exist as of now cannot be challenged.
No, that's true. The effect of upholding the COs is to ensure that, my lords, this anomaly doesn't exist anymore. I am respectfully submitting, my lords, that I am placing this submission from the perspective of rights which are being made available by the impugned COs. That's the point I'm making. One more anomaly to add to what fell from my Lord Justice Khanna may have a look at it. Section 2, subsection 2. Any person who before the day of 1954 was a state subject of class 1 or class 2 and who having migrated after the 1st of March 1947 to the territory now included in Pakistan, returns to the state under a permit for resettlement in the state or for permanent return issued by or under the authority of any law made by the state legislature shall on such return be permanent resident of the state. So you make an exception out of this by saying those persons who may have gone to Pakistan, if they come back, they'll get the benefit.
Any persons also who was.
Yeah. The anomaly is writ large.
No, this included in Pakistan will not include Pakistan occupied.
No, it won't. That they are very clear.
It will not include Pakistan.
No, it won't. That's why a separate provision is brought in.
It will be portions other than.
Other than POJK. There is one other, my lords, very ironical aspect. The Jammu and Kashmir constitution makes provision for seats for POJK in the assembly, but says because it is under. 1 minute.
Time is up.
I know, my lords. That's why. Now there are two other perspectives I'll place and then I'm done, my lords. In fact, this is something which nobody has referred to. That's the reason why I'm even troubling my lords with some of the nitty-gritty of this, my lords. So this is one aspect. 35A, just have a look at that for a minute, my lords. Now, because there's a striking parallel to 31B under the constitution. Koilo, please see the kind of dilution which took place in Koilo. Just have a look at 35A for a minute, my lords. This will be volume 1, PDF page 99. Okay. May I read the words? Notwithstanding anything contained in this constitution, no existing law in force in the state of Jammu and Kashmir and no law hereafter enacted by the legislature of the state defining the class of persons who are or shall be permanent residents of the state of Jammu and Kashmir or conferring on such permanent residents any special rights and privileges or imposing any other persons any restrictions as respects employment under the state government, acquisition of immovable property in the state, settlement in the state, or rights to scholarship or such other forms of aid as the state government may provide shall be void on the ground that it is inconsistent with or takes away or abridges rights conferred on the other citizens of India by any provision of this part. Now, 31B, my lords, under the constitution provides that anything included in the 9th schedule shall be immune from challenge on grounds of violation of part 3.
Guru, now I also note that in your written submissions, you've
Yes.
really highlighted, what was the anomalies and what has been restored now.
Exactly.
The rights perspective.
That's
So,
right.
I think let's go into the
Just
next step. Yes.
three more things, my lords. I'll take only 3-4 minutes, my lords. Now, 31B in Koilo, my lords, very extensively referred to the foundational value of the fundamental rights. Golden triangle of 14, 19, and 21. I've given all those paras in my submissions, my lords. In fact, I've given the extracts of all those paragraphs in Koilo. Now, ultimately, my lord said, you cannot take away judicial review and any law included in the 9th schedule can be tested on the anvil of basic structure. Now, surely you cannot have a position, and that's what petitioners are bargaining for. What was there in the original constitution, my lords, this is the approach of this honorable court. The petitioners can't bargain for a position where the Jammu and Kashmir constitution, which is admittedly inferior, in terms of, my lords, the constitutional governing instrument than the Constitution of India. They have something better than that. This is the kind of importance which has been given under the constitutional scheme of India. In fact, 31B itself, my lords said at one part in paragraph 78, just make a note of it, the validity of 31B was not in challenge and therefore my lords did not go into it. My lords assumed that in Shankari Prasad and in Sajjan Singh it was upheld, therefore my lords didn't go into it. But instead, judicial review cannot be excluded. And you cannot say, by placing it there, I'm making it immune to challenge. That's precisely what 35A purports to do. That's the second part, my lords. Third part, ultimately, my lords, all the nuts and bolts and the nitty-gritty looked at. What does it come down to, my lords? The basic structure is the Grund norm. That's the touchstone on which any constitutional decision making has to be considered. The validity of any constitutional decision making has to be seen. Today, what are they, my lords, arguing in terms of basic structure? At the highest, apart from, if I may say so, diffuse arguments of fraud on constitution. Two square features which they want to invoke, my lords, in various forms. One is federalism. The other is, my lords, representative government. So far as representative government is concerned, I think that already the solicitor has pointed out, it's a Puducherry model, there is representation. So far as federalism is concerned, the highest that they are able to put it on is some kind of a derivative form of federalism based on what my lords have said in the 2023 NCT judgment. That's the highest they want to put it at, where they say that my lords are referred to an asymmetric federalism. Paragraphs 40 and 41 of 2023, my lords have been given, the citation is there in my notes of submissions. What they want to say now is, asymmetric federalism has been recognized. Now please stretch this and say the multisymmetric federalism of 370 should also be taken to be a basic feature of the facet of federalism. That's the argument. I'll give the page numbers of Dr. Dhawan's arguments. Page 280, page 211, volume 1 of submissions. After extracting from my lord's decision in NCT in 2023, they say that this now has to be stretched further to say multi-symmetric federalism. There, para 40 and 41 of 2023 at the risk of carrying coal to Newcastle, my lords. My lords, interestingly, have referred to 371 and all those provisions for various states by way of special provisions. My lords there refer to how they are special provisions in 371. And it is on that basis, by relying on the marginal note. My lords have pointed out how constitutionally some kind of asymmetric arrangement has been made. So it is on the basis that it is a special provision in 371. Today, what they want to do is equate 370, which is temporary, with 371 special provision. I hope I'm making myself clear.
Yes, yes.
Therefore, that is why I said it's a derivative argument they want to make. 371, my lords consciously referred to the marginal notes and said how these are special provisions, and that's how they provide for special provisions. That cannot be stretched, my lords, to say that it has to be applied to 370. The temporary character, nuts and bolts of 370, all of them have been argued, my lords. I don't want to take the time anymore. I'm adopting those arguments. In the light of that, my lords, I would respectfully submit. In fact, the impugned COs are reflective of transformative constitutionalism. What was argued by Dr. Dhawan, in my respectful submission, the boot lies on the other foot. The impugned COs ensure that the Constitution of India, with all its plenary scope, applies to the state. In my respectful submission, my lords, the challenge of the petitioners is really a contradiction in terms. Because this is a case where the application of the Constitution of India, the plenary document, is sought to be challenged. The effect of the COs is to ensure that the entire Constitution applies to the state, with all Part 3 rights, with all the other provisions. And even on federalism, my lords, there is one other portion in the opening remarks of Dr. Ambedkar while placing the draft constitution, my lords, before the assembly, constituent assembly.
Mr.
I've
Giri has
extracted,
extensively read it.
no, there is another portion apart from what Mr. Giri read. So I've extracted that in my submissions, my lords could have a look at that.
We'll see.
Therefore, my lords, in sum and substance,
Thank you, Mr.
in sum and substance, my lords, this is for perpetuation of vested rights. And the COs, my lords, make provision for realization of rights under the constitution. I'm obliged.
Thank you, Mr.
Yes.
Who are you appearing for?
I am for the writ petitioner who had filed the writ petition in January 2018 against the effacement of all articles in respect of me in relation to Jammu and Kashmir. Part 3, effacement of Part 3, a core value from the Part 3. I challenged that before this court and that has been tagged. Enough has been argued, but I am arguing for class, that's Radhika Gill versus Union of India.
Which is that?
Radhika Gill versus Union of India, and my synopsis is at page, the compilation is 426. I'll take only 2 bits, my lord. This Radhika Gill and the other person belongs to that class who are descendants to those persons who have been lifted from Gurdaspur to Jammu and Kashmir in 1957 to handle the sanitation problem which had arisen on account of the long strike in Jammu and Kashmir. So they were settled in the outskirts of Jammu and Kashmir, and my lord, that now has converted now with the passage of time. Those are the slums, no property rights, etc., no education rights, etc. Now, my lord, your lordship may kindly see my prayer. The whole effacement of Part 3 in relation to Jammu and Kashmir, I have challenged in my writ petition. Your lordship may kindly see the Solicitor General referred to Article 14 effacement also. Your lordship may kindly see 35A, Clause A. What exactly it does? It does one thing, my lord, delegating the power to the state legislature to define the permanent resident and not challengeable. That's what, my lord, the delegation has been done to the state government, state legislature, my lord, in this class, my lordship, defining the class of permanent resident and delegating it to state legislature and not challengeable. So, my lord, your lordship have not allowed such a delegation to the state government so far as the Part 3 aspect is concerned. So that's what the solicitor said, that core value of Article 14 has also been taken away. And with the aid and assistance of this delegation, Section 6 was incorporated, and this is nothing but a homage to defined ancestry and none else. Whosoever is there on a particular cutoff date, I was there in 57 only, my lord. So my predecessors were in 57. And we were there, and now we are denied. I am born there, and at least no fundamental rights are available to me. That's why I challenge that right to education. Section 6 has also been challenged in that petition. Now, your lordship, I am now, so far as my synopsis is concerned, paragraph 17 and subparagraphs have dealt with 3 aspects. One is the powers precedent are constant in nature. The lordship may kindly see paragraph 7, subparagraph B.
That's been argued. That's been
now, one thing.